Welcome to the second podcast for this week. So let's start looking at the statutory demand process, because this is the presumption of insolvency that's most often used. So as I said in the last podcast, the most important presumption under section 459 capital C subsection 2 is where a company has failed to comply with a statutory demand. Section 459 capital C subsection 2 paragraph A. Keep at the centre of your mind that here an outsider creditor is seeking to establish that a company is insolvent for the purposes of applying to the court to have the company wound up in insolvency. We can do this by directly proving that the company is insolvent, can't we? We've already talked about that. But this can be expensive and really difficult for an outsider, that is an individual creditor. Instead, the creditor can try to rely on one of those presumptions of insolvency. And here we're looking at the presumption contained in section 459 capital C subsection 2 paragraph A, which establishes a presumption where the company has failed to comply with a statutory demand in the last 3 months. So the rules around statutory demands are quite detailed, but they are set out in the legislation. So you need to read through the relevant sections. Section 459 capital E subsection 1 says that a person can serve on a company a demand relating to a debt or debts that the company owes the person that is or are due and payable, and the amount must be at least the statutory minimum, which is $2,000. Section 459 capital E subsection 2 provides that the demand must specify the debt and its amount, require the company to pay the amount of the debt within 21 days after the demand is served on the company. It must be in writing and in the prescribed form, which is form 509 capital H, and be signed by or on behalf of the creditor. Okay, so the debt must be due and payable. So you can't issue a statutory demand if the debt is still a contingent debt. Now, you don't need to have a judgment in your favour as the creditor serving the statutory demand on the company regarding the debt. Just a standard debt owing on a contract is sufficient. Now, if the demand is not based on a court judgment, which I've just said is fine, then you need an affidavit to verify that the debt is due. Section 459 capital E subsection 3. And if there's a judgment, the judgment must be attached to the statutory demand. If you don't attach that affidavit, it doesn't automatically mean that the demand is invalid. So if that happens, the creditor who failed to attach the affidavit to the statutory demand is best to wait and see if the debtor company will try to have the statutory demand set aside. So the statutory demand must be served on the company. And please have a look at section 109 capital X of the Corporations Act for how a company may be served. Now, if you don't follow section 109 capital X, your service of the demand still complies with the Corporations Act. So if you haven't complied, you might still be able to show that you have served the demand, provided that you can show that it has come to the attention of the company. Okay, so if you don't comply with section 109 capital X service requirements properly, then as a creditor you might still be able to show that the service of the demand, statutory demand came to the attention of the company. So for example, that usually means come to the attention of the relevant people, which may mean the board. So how do you show that the document has come to the notice of the company? So the cases on your PowerPoint are examples. And for example, in Carlino Enterprises, the statutory demand was served on the old registered office of the company, but nevertheless it was forwarded to the company and came to the company's attention. And this was held to constitute proper service despite the lack of compliance with section 109 capital X. Okay, in the case of M. Hill and Bonzak, on the PowerPoint, your second point there, the original statutory demand was handed to a director, and that was deemed to be proper service despite the section saying a copy of the statutory demand is required. So just remember that if you follow section 109 capital X, then you don't have to show that the statutory demand came to someone's attention. So that's the main point to take with you. Now, as we know, a failure to comply with a statutory demand gives rise to that presumption of insolvency, section 459 capital F. If the period for compliance with the demand has expired, that is, that your 21 days is up, it isn't possible for the court to extend the time to comply. This is an important point. So in other words, section 459 capital F comes into operation once that 21 days are up. And the High Court case in Aussie Victoria Plant Hire, which is on your PowerPoint at point 2, said that once the statutory demand time has expired, you cannot extend it. In this case, the company had applied to have the demand set aside, and they failed in the court and they wanted to appeal that decision. They hadn't asked the court for an extension for compliance, and it took several months before the appeal came on. Obviously, during that time, the 21 days was up. And when they got to the High Court, the court said, well, the 21 days has expired and there's no right for an extension. If you do challenge the demand within the required 21 days, then it does enable the court to extend the compliance period as the court wishes, or 7 days after the application is finally determined. If the debtor company wants to challenge the demand, they must comply with section 459 capital G. The company can apply to the court for an order setting aside the statutory demand, and remember this has to be done within the 21 days. So the challenge to the court has to be done within 21 days, and you can't get an extension of time for that period. And the High Court held this in the case of David Grant and Westpac on your PowerPoint. Section 459 capital G has to be strictly complied with, and you can't utilise any of the other powers within the Corporations Act which enables the court to extend time. So this is a really important point. Now, if you're applying to if you're the company and you're applying to set aside the demand in the federal court, there is the Civil Dispute Resolution Act, and this act requires that anyone who institutes civil proceedings in the federal court must file a genuine steps statement at the time of filing the application. So this is a statement that states that you genuinely tried to settle the matter before coming to court. And this is a bit onerous in this case, particularly when you only have 21 days to apply to the court. Some types of procedures are excluded from this rule under that act, but setting aside a statutory demand is not one of them. So you need to make an attempt, if you're the company, to settle the dispute with the creditor around that demand. And the case on point for this is the final case on your PowerPoint, Superior IP International. Okay, when applying to have a statutory demand set aside, the debtor company must identify the grounds for setting aside that demand. They need to file a supporting affidavit with the application, providing details of the reason or reasons to the objection with sufficient detail. This is so that the creditor can identify why the debtor is objecting to the demand. And these principles are often referred to as the Grey Winter principles from the Grey Winter Properties case on your PowerPoint. Copies of the application for setting aside and the affidavit must be served back on the creditor within 21 days. So the creditor has served the debtor with the statutory demand, and then the debtor, if they're disputing it, is serving back on the creditor, aren't they? Okay, Form 509 capital H does require that the address for service on the creditor issuing the demand be in the state or territory where the demand is served. So what does this mean? If the creditor company serving the demand is in Victoria and the debtor company is in, say, Brisbane, so Queensland, they will have to serve the demand in Brisbane, and in addition, they're required to have an address in Brisbane where the debtor company can either serve the creditor if they're trying to have the demand set aside, or to have the demand set aside. Okay, so as you can imagine, sometimes the creditor will fail to do this. If they do fail to do this, if the debtor company still wants to have the demand set aside, they still have to serve the application to have it set aside on the creditor interstate. Even though the creditor has failed to give the debtor company an address in the state, the debtor still has to serve the creditor interstate. This is an important point. Also, the debtor company cannot just ignore the notice because the creditor company failed to give them an address in the correct estate. And the case of sustainable organics up on your PowerPoint at point 2 is authority for this. Now, when you do get to challenge the demand, you can only challenge the demand on 2 potential possible grounds. One under section 459 capital H and the other under section 459 capital J. So when you want to challenge the demand as the debtor company, you need to establish one of these things, and section 459 capital H is the easiest one. You can challenge the demand if there's a genuine dispute between the company and the respondent about the existence or amount of the debt, or the company has what's called an offsetting claim. So the argument here is that there is an amount that the creditor owes to the debtor. Perhaps, for example, for damages because the goods supplied were faulty or delivered late, and due to this loss was suffered. If the amount of the debt comes below that $2,000, then the demand will be set aside because it's below that statutory minimum. Otherwise, if it is accepted that there is still an offset but it doesn't extinguish the debt, then the debt can be offset, that is reduced. So if you have a disputed debt, the offset has to reduce the debt to below $2,000, the statutory minimum. Otherwise, a demand will not be set aside by the court. If it's still above that $2,000, the demand will still stand and the court can extend the time for the payment. Now, if you want to establish that you have a genuine dispute, then you don't have to actually prove your case at this stage. You just have to show some sort of bona fide dispute. So this is the debtor company. The court is fairly generous in finding that there is a genuine dispute. This hearing isn't about proving the actual dispute to be settled. That's obviously dealt with in separate litigation. So if you're disputing things with, the tax department, the mere fact that you've lodged an appeal on your tax assessment because of certain provisions in the tax legislation, that will not amount to a genuine dispute. The way the tax legislation works is you need to pay the debt up front, and if your appeal is successful, then you get your money back later. And the reason why I have raised the tax department here is that they use statutory demands to pressure people to pay outstanding debts. So we've just covered one possibility. If you have a dispute about the debt or the amount of the debt, then you can apply, so this is a debtor company, under section 459 capital G. You have to do it within 21 days and serve the creditor and give them an affidavit establishing why you're disputing the debt. And remember that you have to get it below that minimum if you want to have it set aside altogether. The other ground, which I just briefly mentioned before, is under section 459 capital J. The court may make an order setting aside a demand if it's satisfied that because of a defect in the demand, substantial injustice will be caused unless the demand is set aside, or there is some other reason why the demand should be set aside. Now, defect is actually defined in the dictionary section of the Corporations Act, section 9, which says it includes an irregularity, a misstatement of the amount or total of the debt, a misdescription of the debt or other matter, and a misdescription of a person or entity. Section 9 has a long list of what may be a defect, so have a look at that. In the case of Topfelt and the State Bank of New South Wales on your PowerPoint, the court held that Section 9 is not, in fact, an exhaustive definition. It's just an inclusive one. So in other words, you can have other types of defects as well. Now, importantly, Section 459 capital J, subsection 2, says, except as provided in section 459J subsection 1, the court must not set aside a statutory demand merely because of a defect. So in the case of Spencer Constructions on your PowerPoint, the court said, if the defect is in the demand, it is only to be set aside if substantial injustice will be caused by the defect unless the demand is set aside. So that substantial injustice element is important. It is often easy to find a defect in a statutory demand. For example, a spelling mistake in the name of a company or a misstatement in the address. But it's fairly difficult, isn't it, to establish that that defect will cause substantial injustice. And you can only set aside a demand under section 459 capital J if you can show that there is a substantial injustice. So in the case of B&M Quality Constructions and W.G. Brady on your PowerPoint, this is, I guess, a slightly strange case really. You had a statutory demand referring to W.G. Brady Proprietary Limited. But the creditor was actually W&J Brady Proprietary Limited. This was held to be a defect, so the question was it trivial? The problem for the debtor was that if they wanted to challenge the demand, they would have to serve a company called W.G. Brady Proprietary Limited, when in fact no such company existed. So normally, if you have a situation where the ACN number, so the company number, is correct, it usually saves the creditor because it's strongly arguable that it's then a trivial defect. If the ACN number's wrong as well, then you have more difficulty and you might be able to raise that issue of substantial injustice. So another example is the case of Spencer Constructions on your PowerPoint, where the failure to specify the correct registered office of the company was the defect in the demand, and the court held that there was no injustice caused by the defect, and the court chose not to set aside the demand. Now recall that section 459 capital J, subsection 1, paragraph B, also provides that the demand can be set aside by the court if it's satisfied that there's some other reason why the demand should be set aside. Remember me saying that before, that's a very wide reason. This gives the court wide discretion, doesn't it? But in Spencer Constructions, the court said that this cannot include a defect in the demand. Examples falling within this are abuse of process, a lack of an affidavit, or service problems, but not a defect in the demand. Now, under paragraph B, you don't need to show substantial injustice. So in summary, the debtor company needs to challenge the demand under section 459 capital G, and they can only do it on the basis of the reasons under section 459 capital H or under section 459 capital J. If you do manage to establish that there is a reason for having, so this is the debtor company, does manage to establish that there's a reason for having the statutory demand set aside, then what's the effect of setting aside a statutory demand? Well, section 459 capital K says that the statutory demand has no effect while there is in force under section 459 capital H or capital J an order setting aside the demand. So in other words, the statutory demand has no effect. Now, this doesn't mean that the debtor company is totally out of the woods, because the creditor can possibly also apply to have the debtor company wound up by simply proving insolvency, remember, rather than relying on a presumption. So what we've been talking about is one of those presumptions of insolvency, haven't we? But if that fails, then the creditor can also attempt to have the debtor company wound up by simply proving insolvency. But we've talked about how that can be difficult for a third party outsider, a creditor, to prove. And it's a time-consuming process as well. Okay, so just an important note. It is always possible for the debtor company to prove that they are solvent. So the presumption of insolvency is, of course, rebuttable. However, they do have to wait to do this until the creditor actually brings the application for winding up of the company. So the debtor company can't go back and try to litigate the statutory demand again. They should just try to prove that they are solvent and argue that therefore they should not be wound up in insolvency. Okay, so that's the end of this podcast. When you're ready, move on to the next.